Look, Jeff, be reasonable. All the evidence indicates that Lefty James did hold up the bank. But it's an open and shut case.
That's not the way I see it. All the evidence is circumstantial. There's not a shred of direct evidence.
You don't think that alibi would hold water? Why not a jury in the country
Jeffrey, I just saw Andrew's car pull in the drive.
But the play isn't finished.
Why, no, it's written up to where the jury files back into the jury box.
But we can't agree on a verdict.
Well, isn't Andrew coming here to check your play?
Yes?
He's been practicing law for 15 years. Why not let him decide your case?
It's a deal.
Fair enough.
Come in, Andrew.
Hello, Virginia.
It's a good thing Jeff has his eye set on a legal profession, or I'd never get to see my favorite brother.
Hi, Uncle Andrew.
Hello, Jeff.
You know my friend Hal Fleming.
Of course I do. Hello, Hal.
Hal's been working with me on this play we're writing for school.
Oh? And is this a model of your set?
That's right. It's supposed to be a...
Excuse me, but is it all right with you men if I stay around?
Of course, Mom.
Yes, indeed. You never know when you'll find yourself in court.
Why, Andrew, you don't think I'll turn criminal, do you?
Our courts do a great deal more than punish criminals. Suppose, Virginia, you were run over by an automobile and required expensive treatment. You might have to go to court to recover your damages. Suppose Jeff did some work for a man who then refused to pay.
I'd sue him for breach of contract.
Right. And suppose Hal were falsely accused of advocating the overthrow of the government. The courts would protect him from false imprisonment.
But if he were guilty, the courts would punish him.
I didn't say anything.
Purely a hypothetical case.
Oh.
But seriously, it's because our courts serve so many different purposes that we have so many different courts.
And the court in our play is a criminal court, part of a state circuit court.
Known in some states as the state district court.
As the play opens, the judge is sitting on his bench. And the jury has been selected and sworn in. I'm playing the defense counsel here at the counsel table, beside the defendant, the man who's being tried.
I'm playing the prosecutor, the state's attorney. Then we have the bailiff, the court clerk, the court reporters, who take down all the testimony in shorthand. Then the various witnesses take the witness stand when they are called.
All right.
We start our play with the opening statements of the attorneys.
As prosecutor, I'm first. I tell the jury what I intend to prove and give a general account of the facts that I will present in evidence.
But I tell how the defense will disprove the state's case and show the defendant to be innocent. We both lay it on heavy.
Then as prosecutor, I call up my first witness.
That's right. The witness takes the stand and is sworn in. Once he is sworn in, he must speak the whole truth and nothing but the truth. On this subject, our laws are very strict. For it is only by the administration of true justice that we can preserve our individual rights and live together in a decent society. Now, Mr. Prosecutor.
I call as the first witness a teller of the city bank. Under my direct examination, he testifies that on the morning in question, at about 11 o'clock, a masked man entered the bank and, at the point of a gun, forced him to hand over $30,000.
I cross-examine the teller to bring out that he cannot identify my client as the robber.
Then I call several other witnesses, people who were at the bank at the time it was held up. They testify that the robber's height and other physical features were like the defendant's.
This is all direct evidence. You witnesses directly saw and heard the crime committed.
That's right. And then I introduce in evidence this.
What is it?
A truck driver's badge that we prove beyond question belonged to Lefty James.
But what about it?
One of my witnesses found this badge on the floor of the bank immediately after the holdup.
But does that prove Lefty held up the bank?
Of course it doesn't. It's only circumstantial evidence.
That's right, Jeff. This badge only tends to indicate some particular action or circumstance. That's why it's called circumstantial evidence. But of course, circumstantial evidence is admissible in a trial.
Well, is that all the evidence you have against this Lefty James?
Oh, no. Next I put on the witness stand Lefty's next-door neighbor, and he testifies. I was late getting home that night, but me wife tells me there's been some goings-on over in Lefty's house. Not me wife, she says. That Lefty James is up to no good.
I object. Your Honor, I object to hearsay testimony and ask that it be stricken from the record. and the jury instructed to disregard it.
Objection sustained. The jury will disregard any testimony as to what someone else told the witness.
Good. That's the way we wrote it.
Now, what's this all about?
Well, it's the duty of the judge to see that the trial is conducted properly and fairly, and to decide all legal questions. Evidence of this sort, what somebody thinks or merely heard about, is not admissible in a trial.
And when I asked the witness whether he'd ever seen Lefty James wearing a dark brown suit,
I object again to a leading question.
What does your judge rule this time?
He overrules my objection, and so I take exception. Isn't that one way to lay the ground for an appeal?
Yes, it is.
For all this legal talk, it seems to me you boys are giving the case mostly against Lefty James.
That's because the prosecution presents its witnesses first. Then as defense counsel, I step in. Isn't this the time to move for a directed verdict?
You could.
Directed verdict. Doesn't that mean the judge directs the jury what verdict to bring in?
That's right. You see, I could claim that the state has not made out a case which would legally support a conviction.
But courts are very reluctant to grant such motions. Let's assume, Jeff, that you are overruled and take the usual exception. Then does your defendant take the stand?
Yes, he does. I know an accused man doesn't have to testify in his trial, but on the stand, my client testifies that first, he was in the bank that morning on business, 1 hour and a half before the robbery took place. Second, he left town immediately in his truck and drove to Canfield. Third, he was in Canfield 1 hour after the robbery was committed, and you can't make that 60-mile run in a low-speed truck in 1 hour. And I produce other witnesses to prove he was in Canfield.
but my cross-examination tears a hole in the alibi. There was plenty of time for Lefty to drive the truck out of town and turn it over to an accomplice who would drive it on to Canfield, while Lefty slipped back into town in an automobile. Then Lefty could stick up the bank, drive the car to Canfield in an hour, get back in his truck, and be there to establish his alibi.
But Lefty says the truck had a breakdown. And then I put on the witness stand the owner of a garage who testifies that the truck did stop there for repairs.
Yes, the truck, but he can't make positive identification of Lefty.
That's because Lefty was under the truck trying to fix it, and his face was all muddy and greasy. But the witness says, that sure looks like the driver, and that driver was in the garage 30 miles out of town at the time the holdup was staged.
Well, that ought to convince your jury.
Well, maybe so. But then comes my time to cross-examine the defendant's witness. And I asked, when you finished working on this truck, did the driver sign a service ticket? Yeah, they always do. Did you see him sign? Sure, I gave him the ticket and he signed it. Now, think carefully. Did he sign with his right hand or with his left hand? He signed with his left hand. How do you know? Because he started to write with his right hand, then seemed to change his mind, and then he signed it with his left hand. Now, would you say this man, this truck driver, was naturally a right-handed person and was only trying to act as though he were left-handed?
Your Honor, I object. That's a leading question. Moreover, this witness is not a handwriting expert.
Overruled.
Then I do introduce a handwriting expert who testifies that the signature on the service ticket was not, in his opinion, written by a naturally left-handed person. And remember, our defendant was generally known as Lefty James. Then our expert testifies that he compared the writing on the service ticket with specimens of Lefty's genuine handwriting, and that it was not his handwriting.
Well, you certainly make it sound possible that this Lefty James was the robber.
But possible isn't enough. That's what I bring out in my closing argument, after the prosecutor has made his.
As prosecutor, I review all the evidence tending to show that Lefty James did rob the bank. And then, in the name of the people of the state, I ask that the jury return the verdict of guilty.
As defense counsel, I summarize my case, point out all the weaknesses in the state's case, and then I remind the jury. A man is presumed to be innocent until he's proved guilty. Proved beyond a reasonable doubt.
Then I briefly rebut what defense counsel says. And I again suggest to the jury that the state's evidence warrants a guilty verdict.
And now the judge charges the jury.
What's that?
The judge explains the law as it applies to the case and tells the jurors what verdicts are possible under the law. The 12 jurors then retire to the jury room to discuss the case and vote upon it until they reach a decision or verdict. In a criminal case such as yours, the verdict must be unanimous. Finally, the jury files back and the foreman announces the verdict.
That's the way we have it.
And what is the verdict?
Well, we don't know. We want you to decide.
Now, hold on. You've sort of used me as judge. The judge only pronounces a judgment. It's up to the jury to decide the guilt or innocence of the defendant. Virginia, if you were on the jury, what would your verdict be?
Why, I don't know. We really haven't heard the full case. But I think I'd vote guilty.
Why, Mother, how can you say that? Just because some garage mechanic says...
Now, Jeff, you can't argue with the verdict of a jury. But you can appeal that verdict.
Of course. I could carry the case to the Court of Appeals. Or maybe even up to the state Supreme Court.
That's right. And in the appellate court, a group of judges review the entire proceedings, as recorded by the court reporters, and determine whether the defendant has been given a full and fair trial.
Well, if the verdict were innocent, could the prosecutor appeal?
No. In a criminal case, only the defense may file an appeal. In a civil case, either party may appeal.
Well, then, our play should end with me as defense counsel asking for an appeal.
Yes. And that's a good way to end it. Because it shows that while our courts serve to punish the guilty, they also safeguard individual rights and liberties. By offering fair and open trial to all men, our courts fight to preserve democracy.